Good morning. This is Rich Sierra. I'm the CEO of the Florida Small Business Legal Center. This is episode 47 of Business SOS. We're almost getting close to that number 52 or the 1 year anniversary. So I'm very excited about this. Every week we provide you content that deals with for business owners. And the premise of the podcast is to talk about the common mistakes business owners make and how to avoid them. It's basically a spinoff of my book, Business SOS, but also talk about legal topics that are of interest to small business owners to help you navigate the waters the legal challenges that you will be facing throughout your journey. Before I start, I'd like you to participate in the show. If you want to send me an email and about the legal questions you may have, and I'll address it at the show. My email is rich, R-I-C-H, at richsierra.com. If I select your question and I'll address it at the show, I'll send you a free copy of my book, Business SOS, A Common Legal Mistakes Business Owners Make and How to Avoid Them. It is available on Amazon, Barnes & Noble. You can ask for it at your local bookstore. Today we're going to talk about arbitration and versus court litigation. So many contracts that I see coming my way now and happened this week is that people look at contracts where there is a franchise agreement, where there is now any type of a software contract. I see them as well. That the dispute resolution that is selected in the contract is arbitration. And when I ask my clients, do you know what arbitration is? They say no. So you agree to that. So let's talk about that. Let's talk about what is arbitration. I want to talk about the pros and cons of arbitration. I also want to talk whether, you're better off going to an arbitration process or court-related litigation as well. A little bit on the Florida Arbitration Act, Federal Arbitration Act, and also some topics in the American Arbitration Association as well, which provides a great deal of resources. Again, this is designed to give you an overview, and my objective with this podcast today is that when you are looking at a contract and, one of the sections that I recommend everyone to look at, in addition to the obligations between the parties, is how are you going to resolve the dispute? So if you see, the matter is going to be resolved through mandatory arbitration, at the very least, I want you to understand what that means and not gloss over it and understand, okay, what is arbitration, how this is going to get resolved. So what is arbitration? Arbitration is a form of alternative dispute resolution. The analogy that I give to my clients is basically it's like a private court, because in essence, it's what it is. So you basically choose not to go through a traditional court system, whether a circuit court or federal court or district court, and instead of putting your case in the public, which will be in this case in the court system in your state, in Florida in this case, or in federal court, you choose to go to arbitration. And in this particular case, you can have a retired judge. That could be an arbitrator or an attorney who's a qualified arbitrator. I myself a qualified arbitrator, although my practice, I do not practice in that area, but I became a qualified arbitrator many years ago to understand the process as well. So, and when you hire this arbitrator, then that arbitrator will take over the case. And the arbitrator becomes the de facto judge of this case, and then this arbitrator will set the agenda for the case. So it's a private court. There are benefits to that. There are benefits to having an arbitration procedure versus going through the court system. One of the benefits of going to arbitration is that it's faster. The arbitration is designed to really give you a fast resolution to your problem, to your legal dispute. So the arbitrator once the arbitrator gets retained, and the arbitrator has to be paid separately. We'll talk about that in terms of the potential cost of an arbitration. Once the arbitrator gets retained, The arbitrator sets a case management conference similar to what a judge will set. The arbitrator will discuss with the attorneys, okay, how much time do you need for the case? How much discovery do you need? How many interrogatories, how many witnesses do you anticipate? So based on that information, the arbitrator will set the date already in advance when this hearing is going to take place. Whether it's going to be in person, whether it's going to be via Zoom or via telephone, most likely be either in person or via Zoom, you'll have a fast resolution. So you'll have basically an agenda. You'll have, say, okay, you know what? We're going to have this matter set in 6 months. So your hearing is going to be perhaps a full day hearing based on the number of witnesses that you may have, based on the discovery that either party will need to produce. The depositions will have to be taken. So you'll know in advance, you'll know right there when your hearing will take place. Compare that to a court system. Say you go to circuit court, the matter, that dispute is $100,000. And so that will be circuit court in the state of Florida. Any controversy, the amount of controversy over $50,000 goes to circuit court. So even in a fast track process in circuit court, you're looking at a minimum of 12 months. So that, and it could be 12 to 18 or 24 months, the max if it's complex. So 12 months from the date that is filed. So the benefit of arbitration is a faster process, and you have a degree of certainty about when this matter is going to get adjudicated or resolved, unless you decide to settle it beforehand. So it is a faster process. Why is it faster? Because one of the things that the arbitrator will do is limit the discovery. They will have, in circuit court, and I talked about discovery in prior episodes, you have, 30 interrogatories. You have 30 requests for admissions. You have, unlimited, basically, request for production of documents that you can request. You also have a number of depositions you can take, and depositions of any witnesses that might be relevant unless they're objected to. You can take depots all the way up to the discovery cutoff deadline, which is sometimes about 30 days before trial. So it can be overwhelming, and you can continue the discovery process. So an arbitrator will say, okay, how many interrogatories do you need? So he might say, okay, I'm going to limit it to 15 interrogatories each of you, each party. I'll limit it to 15 requests for admissions. You can do, 25 requests for production of documents. I will give you, certain deadlines to, how many depositions each of you need. You're not going to have unlimited depositions when you have a 6-month process, for example. So he'll ask the parties, okay, obviously the parties have to be deposed. And how many witnesses are you anticipating to bring to the trial, to the hearing, in order to prove your case or defend your case? So he might limit, 3 depots each side. Okay, and if anybody needs more additional depots, you can always ask permission to the arbitrator to request why you need that additional deposition, whether it's newly discovered evidence, whether it's somebody that was not identified initially. You can always ask for more, but initially the process is designed to limit, to really compress the process, and so it does not become, a never-ending process of depots and discovery and motions. So the arbitrator will limit, okay, you'll have this particular day, you can have what is called dispositive motions. Motion for summary judgment will be done by this particular day. Mediation, and the parties can go to mediation, say 60 days before. So it'll be a very, very strict calendar that the arbitrator will impose, and it's a great idea. Now in circuit court, we see that right from the very beginning, that, when we file our lawsuits, there's a case management already established that we send out with our pleadings, with our summons, that the court is anticipating that from the time of the filing, when this case is going to be most likely be adjudicated, could be 12 to 18 months. And then the court, on its own initiative or through requesting by counsel, will set up a case management conference right pretty much within the first 60 days of the case to kind of begin to have finality, which is good. You're in a business dispute, whether you're being sued or you're suing, you want to get this resolved as soon as possible, simply because you're not in the business of being in lawsuits, okay? So one of the, I mentioned that the speed is a benefit of arbitration, confidentiality. Everything that happens in arbitration with respect to discovery, depositions, everything, hearings, all that is confidential and does not show up in the public record. There's flexibility. Parties have more control of the process. In this case, you get to choose the arbitrator unless the contract says the arbitrator will be appointed by a panel or the actual service that you utilize, like the American Arbitration Association is one of them. You get to choose. You get to look at the resume of the arbitrator. You get to hire this individual. And it's also expertise. Sometimes you get to choose the arbitrator by their expertise. In the case of circuit court or any court proceeding, you don't get to choose your judge. The judges are rotated randomly, and you're going to get a judge assigned to the case. There's some, in terms of cons or in terms of disadvantages of arbitration, the cost. The arbitration will be expensive. When you don't, you pay your filing fee with the court. That's all you pay. That's all you pay the court system to adjudicate your case. From the very beginning all the way through the end, there's one filing fee. When you are hiring an arbitrator, you're basically hiring a private judge. So this judge will have to be paid hourly, sometimes daily. Could be rates over $600 an hour or more. It could be, it's divided between the parties. If you use a service, I mentioned the American Arbitration Association, there's also another one called JAMS. You have to pay management fees, case management fees to that service to manage the case. And that's all paid in advance. So I'm just giving you an example. And recently I received, I reviewed an arbitration award that one of our clients received. And the legal fees in this particular case exceeded over $70,000 just to the arbitration. This particular case had an arbitration panel of 3 arbitrators. So, it's just one of the disadvantages, if you will, of arbitration, that it can be very expensive. You have to look at that. Also, disadvantage, limited discovery. As I mentioned before, there's an advantage to that, but a disadvantage of that. Simply that you have to basically prioritize what discovery is important to you, which witnesses are important to you, which questions to ask, which third-party subpoenas to issue, because you're not going to have the carte blanche that for the most part we have in circuit court. We look at the witnesses, clearly based on you prioritize as well. You have a little bit more freedom, more flexibility when you are in circuit court. And then when you're in arbitration, that will be limited, and is limited by design in order to shorten the time and get this to a faster conclusion. One of the things, what happens in the arbitration hearing? So let's talk about that for a few minutes. So you have a hearing similar to you have on a trial. You have your arbitrator, you'll have your witnesses, you might have your opening statements. The arbitrator might request some initial opening statements to be done in writing. So that way the arbitrator has that information available to him or her or to the panel. And you present your case to one individual, which is also, to the degree, it's a disadvantage because there's no jury trial here. It's only one individual who will make the decision in your case. But in this case, you voluntarily agree to those terms. There's no such thing in Florida as mandatory arbitration. So you can go to arbitration. There's mandatory arbitration. I'll take that back, but it's non-binding. And in the case the judge requires it. Okay. But that's a different conversation altogether. But for the most part, you're not going to be compelled to go to arbitration unless you agree to do it. So you agree to those terms, you agree to one individual to make the decision on the case. So you're not going to have the benefit of a jury trial in this case. So one individual to present your case, you have your opening statements, the petitioner, the plaintiff is presenting the case, going through witnesses, just like you do in a court of law. The arbitrator, basically it is the judge. So regarding any type of objections to discovery, objections to witnesses, objections to the type of testimony, it's up to the arbitrator. And those are not appealable. So though that this particular hearing, it is private and confidential, meaning that it's not going to show up in a court of law. They're not going to show up in the public record. So the defense presents the case just the same way. And then you have your closing statements. The arbitrator may or may not render a decision at that point. The arbitrator may take all that information and then said, I'll give you my response, my decision, say 15 days, 20 days. So once that hearing is over, then you wait. Then the arbitrator will render what is called an arbitration award. It's not a judgment, it's an award, whether it's for the plaintiff or the defendant. But the arbitrator will write a report specifically on the findings of fact about what the findings were in that particular hearing, what the arbitrator saw, and how the arbitrator arrived at that decision and what law was applied. The arbitrator will then render what is called an arbitration award, whether it's awarding money to somebody or basically saying no, the defense wins. So let's go in this particular case, the plaintiff was able to get an arbitration award. So you won the case, you won your arbitration, congratulations. Okay. There's some good news about having that arbitration award, meaning that appeals are very, very difficult. In Florida, to be able to overturn an arbitration award, it's very, very difficult. You have to claim fraud. You have to claim bias from the arbitrator, or you have to claim abuse of discretion. So the courts are very reluctant to reverse arbitration award simply because the courts are encouraging people to use alternative dispute resolution process, such as arbitration or mediation, in order to resolve disputes, because that's less of a burden to the court system. So they're not going to, it has to be something very extreme to reverse an arbitration award, but, people can try. So you get your arbitration award. So what do I do with this? So say it's a state arbitration award. Say, it's not a federal arbitration award. It's in state court. So you take the arbitration award. In order to convert that into a judgment, which is the next step, you got to get it confirmed with the circuit court. So say you were able to obtain an arbitration award for $100,000. That award is really good in any state, but say you're located in Florida, it's a Florida jurisdiction, say you're in Broward County. So what you do, you basically get an attorney if you're a business entity, and that attorney will have to get that award confirmed with the circuit court. You basically open a case, you file it with the court, you ask for a motion to confirm arbitration award, and then the circuit court, the judge will convert the process called confirmation, but the circuit court will convert that arbitration award into a Florida judgment. Then with that Florida judgment, once that is confirmed, then you can go ahead and execute the judgment. So let me repeat, you have to take the arbitration award, confirm it into a judgment, but the process is confirmation. You got to file it in court and get that confirmed. Once that is confirmed, the defense can try to appeal that judgment. But that's a different conversation. Let's first, for example, it's not attempted to be appealed. So now you have a judgment that you can collect on, just as if you would have won a case in state court. Okay. If you're in that process, you're in the process of arbitration, my recommendation is to get legal counsel and not to navigate an arbitration by yourself. Some people attempt to do it by themselves. Sometimes they're successful. But arbitration processes, they're just as difficult as going through court. In fact, in some cases can be a little bit more difficult to navigate because there's more flexibility from the arbitrator to choose what to do, whether it's discovery, whether it's motion practice. In circuit court, we have our rules of procedure, so we pretty much we follow those rules. And the arbitrations, they have their own rules as well. If you go to the American Arbitration Association website, you'll see, go to rules and procedure, they have their own rules, so you follow those as well. The Florida Arbitration Act, Chapter 682, has rules as well. And also you have the Federal Arbitration Act as well that has the procedures as well. So, it's something that if you're not familiar with, you're not practicing that area, it's not something that I recommend that you do on your own because you can make mistakes. And in an arbitration, if you make a mistake, it's going to be more difficult for you to overcome that because you, for the most part, will not be able to appeal the decision of the arbitrator. In circuit court, you have motions for reconsideration. There are a number of things that you can do to try to fix mistakes. In arbitration, you might not have that option. It's a more compressed time to do it, but also you have less options to try to reverse that. So I just wanted you to keep that in mind. So the selection of, let's talk about if you're in a situation that you are in a business dispute and then you have to select an arbitrator. My recommendation first is get counsel because a lot of times the attorneys know who the arbitrators are, know somebody from the panel. But look at the resumes. All the arbitrators have resumes. Look at their experience. Look at their expertise. Whether they're attorneys are practicing in that area or they're former judges that are retired. And they tell you that all of them have resumes as well. And so that selection is very important. The key here is that both parties have to agree to select the arbitrator. Once the arbitrator is hired, the arbitrator will send a retainer agreement to both parties if you're not going through a specific service. And then you sign that retainer agreement. The arbitrator may not, for the most part, if you are not dealing with an attorney, the arbitrator will require a deposit for him or her to get paid. If it's done through an attorney, the attorney may require you to pay a deposit into the trust account to cover the cost of the arbitration. Otherwise, the attorney can be personally liable for that arbitration cost if he signs that arbitration agreement and then there's no payment. So just be prepared that if you're going to use an arbitration process, you will have to basically upfront significant fees in order to begin the process. The goal here today is for you now, when you look at a contract, and I'm actually, in the next few episodes, I might go over the contract provisions as well. I did that when I began the podcast. I think I did an episode on contract law for business owners and kind of contract provisions. I might revisit some of those topics because what I want you to do is when you're looking at a contract, one of the first things that I want you to look at, obviously, are the obligations, the terms, but I want you to go back. It's usually like in one of the last sections of the contract, is that to really look if we have a problem here, we have an issue here, how is this going to get resolved? And usually you have language, this is, this contract will be interpreted by the laws of the state of Florida. Vetting jurisdiction shall be exclusive to Palm Beach County, Florida. You'll see some language like that, or you will see a language to the effect that this any disputes regarding this agreement shall be resolved through binding arbitration, through the American Arbitration Association, or through JAMS, or through an arbitrator agreed upon by both parties. This shall be exclusive, and it shall be held within 45 days of notice. It gives you kind of a process on how you're going to begin the arbitration, but it's important to understand how it's going to get resolved. So I don't want you to look at the contract and look at the word arbitration and say, I don't know what that means, because then you're signing to something you do not understand. And you know my rule in the contract, if you do not understand the contract, please do not sign it. Get help, get somebody to help you understand the provisions, so that way when you're signing the contract, you're informed what you're signing. And dispute resolution, the dispute resolution clause is really one of the most ignored sections in most contracts from business owners. And I see this time and time again as I do significant amount of litigation work in contract law and contract disputes. And 9 out of 10 times I ask, did you know that there was an arbitration provision in this contract? No, I do not know that. What is arbitration? And in some cases you have, and this is very common in franchises, you have an arbitration clause that says arbitration shall be held, in person in Phoenix, Arizona. You're in Florida. Using Phoenix as an example. The point is this, that you have to understand, okay, you can change that. So listen, if we're going to have arbitration, let's do it via Zoom. Okay. You can basically understand that if you have a dispute, understand how this is going to be resolved, and at least attempted to be resolved or adjudicated. To think that you're going into a contract and say, we're not going to have a problem with this, it's unrealistic. The reality is, every time you go into a contract, there's a potential that there might be a disagreement. There's a potential there might be a dispute. And the reason you want to have the dispute resolution process laid out correctly and laid out as detailed as possible is because it actually runs things smoother that way. So understand that. So if it says you have to have the arbitration in Phoenix and you're okay with that, then it's fine. But at least you know it in advance. There should not be any surprises in the contracts that you sign, especially as it relates to how a dispute is going to be resolved. So this is all for today for arbitration. If you have any questions regarding this topic, you'd like to send me an email, reach out to me. My email is rich, R-I-C-H, at richsierra.com. Again, it's rich, R-I-C-H, at richsierra.com. You want to learn more about our legal services, our office in Boca Raton, our website is Florida Small Business Legal Center.com. We're on Facebook at FSB Legal. We're YouTube, if you want to see the video of this podcast, we're youtube.com/ Richard Sierra. We're on X at Rich_Sierra. We're on Instagram at FSB Legal. If you want to give us a call, my number is 866-842-5202. Remember that Business SOS, 8 common legal mistakes business owners make and how to avoid them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstore as well. If you like the podcast, please follow us. I appreciate a 5-star review and some comments. That helps the podcast grow through the various podcast channels. We're on Apple Podcasts, Spotify, wherever you enjoy your shows. Same thing with our YouTube channel. Please subscribe. Leave a comment. I'll respond to the comment as well. Until next week, this is Rich Sierra from the Florida Small Business Legal Center. Remember that my goal is to help you succeed.